Hello everyone, and welcome back to another episode of the Darrell Brooks saga. On today's episode, we're going to continue with the trial, and Jennifer Dorough, the judge, is actually going to address subject matter jurisdiction for Darrell, since he's been asking for it since day one. But before that, a little plug. As you guys know, I work a lot. I have a 50-hour job that allows me, thankfully, to travel a lot. So I know a lot of places. I've been to a lot of places so far. But if you guys want to see, I'm going to be uploading my past and future trips to my Instagram, which if you can scan that image that is on the screen right now, should take you to my profile. Or if you look on Instagram, hey, I'm Jester13, that should take you there. So I'm going to start uploading pictures of the places that I've been, which is fun. It's tiring, but it's fun. Yeah, let me get that out of the way. And before this video, I just guys know, thank you guys for watching. Thank you guys for giving it a like, giving it a share, subscribing if you're not subscribed. We still have a long way to go with this trial, and I'll be recording more stuff later, so be on the lookout for that. All right, let's get into the video.
I'm going to excuse the jury momentarily to take up a legal issue with the parties, and hopefully we'll have you brought back out shortly. You can
right off the bat, the guy is annoyed because they didn't allow him to ask one final question to the other dude because he was irrelevant.
This opportunity for a comfort break, though. You may make an offer of proof, sir, as it relates to why or what questions and what information you believe this officer would provide about news reports that he has seen.
So the offer of proof would just be to that one question?
Yes, they told you this before we finished with the last guy. She told you specifically that just on that topic, that was the thing that you had to offer proof.
What would the question be?
The question was, would have been, if I was allowed to finish it, had he seen any news reports directly connected to the incident?
But what's the relevance?
The same thing that many other witnesses have been asked, and it was never sustained. Then it was never even objected to. So it was the same. It was essentially
Let's focus
one
on
of the same
the
questions.
specific objection that was posed, and my
what was the grounds for
willingness
it?
to give you an opportunity to provide the court with an offer of proof. This was what relevance would this particular witness seeing news reports have to his testimony?
Yeah, because remember, other people has identified Darrell Brooks, and when that happened, that is fair for him to ask where he got the description. You can argue that it's worthless, but it's fair to ask. That's the reason why the attorneys haven't objected to it. Now that this last witness testified that he never testified anything about Darrell Brooks, only of where the truck was in the surrounding area, and that's it.
The same thing that any other witness that was asked the same question.
Which would be what? You have to be specific, sir. I'm not going to assume I understand what you are saying.
Have they saw any reports related to the incident?
Right.
That's the same question that's been asked by numerous witnesses.
Well, there would be a follow-up to that. So how is it relevant to this witness's testimony?
It's relevant to anyone who gets on the stand's testimony.
What's the legal basis you believe?
You need to explain why. Saying it's relevant is not an argument. Just stating a fact is not an argument.
Believe it's relevant to his testimony, sir?
It obviously forms an opinion.
About what?
Again, you need to explain to me, sir, the legal basis why you believe I should allow that witness to be asked that question and then any follow-up based on his response.
What would have been the follow-up?
I'm asking you, sir, you're the one who's the proponent of this particular testimony and this questioning and the evidence. So explain to me your legal basis for why you believe it's relevant to ask, or any other reason, any legal basis you believe it's that I should allow that question to be asked.
I don't understand how you want me to answer that. I've stated the reason why I asked the question.
No, you stated it.
No, you didn't. You only say it because it's relevant. And this is the reason why I like doing this trial again. Because I could just go around the trial and just pick and choose different moments. Like this moment, I could have been like, oh, Darrell fights with the judge and for a question that he didn't got to ask. But I don't think that it's fair. I like giving you guys context, and that's why I'm going through the entire trial, editing down everything, and give you commentary about it. I don't like picking and choosing moments because you lose the context. And in jury and trials, it's very important to know why stuff is happening throughout the entire trial.
It's obvious, but it's not obvious to me, so I'm asking you to explain it.
I also stated that it
You said it forms an opinion about what? He never described you. He never interacted with you at that point where he testified.
I just clearly stated, that it goes towards biasness.
And here we go with the made-up word. I'm an ACL. I'm an English second language person. But biasness? I don't believe that it's a word. I'm gonna look up if it's a word.
That would be relevant.
Wait, it goes to what?
Biased.
Bias?
Biased.
No, bias. B-I-A-S. There's no T at the end. Bias. I want to make sure I understand your reasoning correctly, sir. So you're saying it goes to bias. How does it go to bias of this witness, sir?
How would it not go to if you see something in the news?
It's not a proper legal.
Apparently, that is not a word. I see bias. I see biased, but not biasness. That doesn't exist apparently.
Argument, sir.
Okay, well, I don't know how you want me to answer
How
that.
would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so what do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof.
Okay,
I said I would recall the witness if I determined.
I'm well aware what an offer of proof is.
Okay.
No, you don't, because right now we're having that moment and you're not doing it. You're just saying it is because I said so.
So make your offer of proof.
I don't need to. It's clear.
There you go. I don't need to. He's like, I know exactly what it is. And then she says, okay, do it. He's like, I don't need to. Then you don't know what it is. And she's laughing. I mean, everyone's laughing at him because it's so ridiculous.
It's very clear. I don't see anything funny either.
I do. I see a clown right on my screen and monitor. I see you guys see a clown, or even the expression of the guy behind it. Look at him. He's like, I'm trying not to laugh, but this guy is not serious.
It's not funny, sir. It's a circular argument. You're telling me that it's clear.
I wasn't referring that to you.
What?
The person that was referred to know who they are.
Well, let's stay on task, please. So
I'm trying to.
You're claiming it goes to bias, but in what way?
May I say this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution can ask essentially anything they want to ask.
Mr. Brooks,
but then when I
had an objection before. Well, here's the thing: you want to go off target. And you want to bring up things from the past. I can't explain to you why sometimes the state has an objection and other times they don't. But when an objection has been made, it is my obligation to rule on it. And so there was an objection.
I'm aware of that, Your Honor. But I'm also aware of the fact, and it's clear that I object quite often.
Quite often? My counter is in 603. This day alone, You have objected 102 times so far, and we still have one witness left. So quite often is an understatement.
Every single time I object is just thrown to the side. Every single time.
Well,
No, that's hyperbole. There were some that you got right.
I would disagree with that characterization, sir.
And why
I
would
make
you
my
disagree with
rulings
that?
in this
Why would
case
you disagree
based.
with that?
I'm like
Can
an
you point out
umpire.
one time?
I'm like an umpire in a baseball game, sir. I call and see the legal objections as I see them. That is my role, and that is what I do. And
Are you kidding me?
Oh, look at those eyes. He's so amazed that she thinks that she's fair, and she is. We all seen her. She is unfair to the state because she helps you. She actually helps you a ton, and you still make that face?
that's exactly
Your
what I
Honor.
do. I'm an umpire, sir.
Your Honor.
I am a referee in this trial.
If you're the
And
umpire
let me
with custody-
finish. Let me finish, Mr. Brooks.
I
Okay?
apologize. I'm letting
So,
you finish.
sometimes parties make objections, sometimes they don't. There can be a variety of reasons. You make a lot of objections in this case. From my perspective, okay, you make a number of objections, I rule on them, and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence. So for example, if there's a relevance objection, I'm going to analyze that, okay, based on the objection that's been made. Sometimes I might think there's another basis for something to either come in or not come in. But my rule book, okay, is the rules of evidence, which are the statutes, which once again, I'll point out, I gave you,
Yep.
sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you choose not to read them, that's fine. But you cannot then claim that there is somehow foul play because you haven't read them and you don't understand what they are.
And that's a very good example by Judge Darrell, is that if I go into, I don't know, a cricket match, and then they keep fouling me over and over because I didn't read the rules. I don't know when to pitch. I don't know when to bat. I don't know when to run, because I honestly don't know how cricket works. But if I go into a match and then the referee is constantly fouling me, and I'm like, what? You're biased against me just because I don't know how to play this game. He's like, you went and played this game by your own will. So adapt to the rules, read them, learn them, and then tell me that I'm wrong.
Ignorance of the law is not a defense
Yeah.
for any of this. Okay? And you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. And I've asked you repeatedly for an offer of proof. You want to ask this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias, for which I will allow him to answer that. You haven't given me a legal or factual reason to overrule the objection and to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, but I recognize it's 3:25. It will be a good opportunity for a comfort break. And when we come back on, the state should be prepared to call the next witness.
Can I release at least rebuttal to what you just said?
No.
Since you
I
asked
don't
me
need
not
a
to
rebuttal, sir. You may not agree with me, but I've made
It's not
my
about agreeing.
record.
You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record.
First of all, you don't deserve nothing. Nothing at all. Second of all, she doesn't need to hear you anymore. She made a ruling. The ruling stands. If you want to appeal the ruling, you do it after, like you're doing right now. Like he's been since February, March, when he fired his attorney, he's been trying to appeal and asking for more time to prepare. And we're going to go into next year and he will not have presented his appeal because it doesn't matter how much time he gets. He'll be there forever.
What would you like to put on the record as it relates to the specific issue for which I was giving you the opportunity to be heard? Not anything else, not subject matter jurisdiction, not
now you
whether
said
the
that.
state's doing
I
other
didn't even bring
things.
that up,
I'm
Your Honor.
only asking you to address the offer of proof.
No,
if
I
you
wanna-
have something, go ahead. But only as it relates to
I want to
that.
address your position because you said you're like the umpire, right?
Well, I'm not getting... Okay, go ahead, sir. I'm not sure why you need to respond to that.
Because it needs to be on the record. If
What?
you're the umpire, that means you're the referee.
Right.
That's what I'm doing here today, sir.
And you're not reffing fair if the jury's not allowed to hear things that's important for them to know.
I respectfully disagree, sir. Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction doesn't
I didn't
make
question
it
anybody
so.
about that.
Okay?
That was
make
between
it
you
so.
and I. That didn't have nothing to do with a witness. I've
You
never
want to
once
question
questioned a
these
witness
witnesses,
about subject
sir,
matter
about
jurisdiction.
whether they are aware of complaints. And the funny thing is, sir, I sometimes let that question be answered for reasons that are completely different, I believe, than why you want them in. I am not going to explain that because I don't have to explain that.
You can't say what's my reason for asking it.
Well, I believe you've made it very clear, sir. So here's the bottom line.
I don't.
One of my
Well, it doesn't matter what you believe, Brooks.
roles is to be the umpire.
Then you got to be
right?
fair, Your Honor. You're a public servant.
I am fair, and I'm
No,
going
you're
to follow
not.
the
You're not
rules
being
of
fair.
evidence,
Your
sir.
Honor,
That
this is
doesn't
why I
mean
say that.
unfettered questioning
This is
of
why I say that.
witnesses that are not relevant or that call for hearsay or for a variety of other reasons that are speculative. There's a whole host of reasons in the rules of evidence, sir, that require me to make those determinations.
You're not being
I
fair.
respect
You're not
that
being
you
fair,
might
though.
not think it's always fair, but
It's
I
not.
disagree with the characterization. I think it has more to do with your lack of understanding of the rules of evidence and the rules of procedure, which you knowingly and freely and voluntarily and deliberately made a choice to represent yourself. And
And you keep saying that because it sounds good on the record, but it's not accurate. You accept it.
It is accurate, Brooks. Yes, she accepted the paperwork because you filed it. But the paperwork said that none of this can be altered. The page itself at the bottom, it said you cannot alter this. So it doesn't matter how much scratches you did. It doesn't matter.
When you gave me the paperwork, Your Honor, I gave it back to you.
I'm not going in. I didn't say that, sir, so we can go back and rehash all of those things.
But you know you accepted
Right.
the way that I gave you the paperwork back. So once
and
you
I made
accept
findings
that,
on the record, which I will stand by, sir. So
and I'm not,
with that,
I'm not
we're going to
arguing.
take.
I'm not arguing your findings.
I
I'm
need
not
a comfort
arguing
break.
the findings,
I'm sure
Your Honor.
you need a comfort.
More witness today?
I would like to get through one more
You got
witness
it.
today.
You got
Thank
it. You got to
We're
call
off
it
the
fair.
record, sir.
You got.
So he believes that because the judge doesn't sustain, like he says, most of his objections because they're nonsense, that means that she is biased against him. Sorry, Brooks, but if you just read the statutes about, I don't know, hearsay, you will know why she's sustaining all of the objections and not sustaining yours. They know what they're doing. You don't. You don't want to learn. And that's the most frustrating part of it.
Before I have the jury brought out and the state calls its next witness, I want to bring to the party's attention that the court just now issued a decision and order in this case. I've signed it. Madam Clerk is pulling it through and I will provide the parties with a written copy here in court. It addresses the matter of subject matter jurisdiction.
There you go.
So we're gonna address it.
No, she already addressed it. We don't do anything. You don't do anything. She already had the decision made.
I've issued an order. I'm going to give it to you. That's why I'm addressing it. You can review it later, but there's a written decision now denying your motion to dismiss.
So is that including verified proof that you have subject matter jurisdiction?
And for people that don't know, sovereign citizens, or at least the tactic that she's using, is that no one has any jurisdiction over you. They believe that you never ever sign a paper where I say that I'm going to follow the rules of society. You never did that. I never did that at all. But as a person, as a human being, I understand you don't kill, you don't steal, you try to be the best person that you can be. Like, all of those things mean something to me. Apparently not to him. So that's why he means that. Is there proof of that? He wants for you to show him a paper where he signed, I'm going to follow the laws of the country. And he's never gonna get that.
Because it has yet to be verified or proven.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
Yeah.
So it doesn't have to be proven?
You are going to get a written decision. That's how I'm addressing this. And then I'm going to have the jury brought out and just providing courtesy copies to the parties as I had an opportunity to finalize that over the break.
Set for value and return for value this document.
All right.
Thank you for noting that. All right, bring the jury out. State has its next witness, I presume, ready to go?
Yep.
All right. When the jury's brought out, you may call the witness.
Is that verified proof that you have subject matter jurisdiction?
The decision and order speaks for itself, sir.
Is it verified proof that you have it?
Sir, I believe it answers your questions.
I don't believe so.
Unequivocally.
There's no
He doesn't believe so. He hasn't never even seen the paper. He hasn't read the words inside that paper. But he's already saying, nah, that is nothing.
verified proof proven yet.
Yeah, it's the same for both.
There's no verified proof if we're in common law or admiralty law. What court is this?
Oh, God.
Sir, I believe your answers will be in that decision and order.
I don't believe so.
Well, have you read it yet?
I don't have to.
Okay.
Look at that. That's the thing that drives me crazy. I don't have to. He is choosing to be ignorant about it because it doesn't support his argument. The only way that this works is that if he doesn't know, if he can claim that he doesn't know, the moment that he reads the actual thing, he will know that he's wrong.
Accepted for value and return for value, so
All right, they're in there, sir. It's a final order for
verified
purposes
proof
of
is in
appeal.
there? Verified proof
So
is in
if
there?
you'd like to challenge that, you can take that up with the appellate courts.
Verified proof is in there?
All rise.
Because
Yeah, and that was the final nail in the coffin of subject matter jurisdiction from the court. He's still gonna call it out because he's him, but it's gonna be a whole issue later. But for now, I want to say thank you guys for watching. I'm so grateful that you guys are here. Remember that you're great, that you matter, and that I'm really happy that you're here. Hope you have a nice day. Bye-bye.